attorney Laura Anthony, founding partner of Anthony P. LLC, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the boom in SPAC IPOs in advance of M&A buying opportunities. SPACs are by nature shell companies as defined by the federal securities laws. Accordingly, SPACs have all the same limitations as any other shell company, including, but not limited to, a SPAC is an ineligible issuer that is not entitled to use a free-writing prospectus in its IPO or subsequent offerings within 3 years of completing a business combination. After completing the IPO and until it completes a business combination, the SPAC must identify itself with a shell company status on the cover of its Exchange Act periodic reports. A SPAC cannot use a Form S-8 to register any management equity plans until 60 days after completing a business combination. A SPAC may not file an S-3 in reliance on Instruction 1B6, which is the baby shelf rule, until 12 months after it ceases to be a shell and has filed Form 10 information, that is the information that would be required if the company were filing a Form 10 registration statement, with the SEC reflecting its status as an entity that is no longer a shell company. Also, recently, the SEC has been issuing comment letters where the company is filing an S-3 in reliance on Instruction 1B1, which is the full shelf rule, or 1B3, which is the resale rule, following a SPAC deal, suggesting they want those entities to wait 12 months as well. Historically, the SEC would include the SEC filings of the SPAC in the general requirement that the company have a class of securities registered for 12 months prior to the use of Form S-3. But it seems they are changing their view and want the operating business to be public for the full 12 months. I wouldn't be surprised if we see a rule change aligning all S-3 use with the current shell company requirements in Instruction 1B6, which is the baby shelf rule. Holders of SPAC also may not rely on Rule 144 for resales of their securities after the SPAC completes a business combination until 1 year after the company has filed current Form 10 information with the SEC, reflecting its status as an entity that is no longer a shell company, and so long as the SPAC remains current in its SEC reporting obligations. As a conclusion, although all forms of going public have pros and cons, in a SPAC deal or other reverse merger, you have a motivated buyer. SPACs are required to liquidate if they do not complete a business combination within the legally specified time period, and the sponsor will lose their investment. In a reverse merger, the current public company must continue to fund SEC reporting requirements, Edgar fees, transfer agent fees, and the usual fees associated with being public, in addition to facing shareholder pressure to either make the current business work or find an opportunity that has the potential to bring them future value. For companies that are looking to go public without the traditional IPO, and especially those looking for growth through M&A activity, now is a great time to look at SPACs and reverse merger opportunities. Certainly, Bill Ackman in Pershing Square thinks so, recently filing for the largest SPAC ever with a $3 billion offering. On the large cap size, he certainly recognizes the opportunities, and those same opportunities will be available in all market sectors. I'm securities attorney Laura Anthony, founding partner of Anthony P. LLC and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.